some things. I think the World Mediators Conference you missed out on, Indigenous Peoples and Mediation you missed out on. That's not fair. It's not
I'm
fair.
back. I'm back.
But really not fair. Your thoughts are and perspectives and insights are very important. So maybe you'll cover up some in relation to Indigenous Peoples and mediation in this, because there
Yes,
will be some connection there.
there will be some connection.
Perfect. So Guna, you'd have to, of course, I know you, but let's just put it out there. Please tell us about yourself and take into the topic, and then give me 30 seconds to talk about the symposium and that. And then after that, we'll take it into the topic. Please.
Sure. Okay, a very good evening to Vikram and everyone who's listening in. Well, we hope there are people listening in. And I'm from Malaysia. My name is Guna. I have been a mediator for more than 20 years. I'm also a mediation trainer. Of course, I'm a lawyer by profession, but I think I would rather hold myself out as a mediator than a lawyer, for reasons which I think like-minded people like Vikram and Cecil before me who spoke will of course say that, you know, this is a more peaceful and fruitful way of trying to resolve a dispute. Being, you know, getting into mediation and getting involved in mediation has actually changed a lot in my own personal life. And I hope that, you know, by listening to all of us in Vikram's symposiums and on various topics in relation to mediation, will somehow lure all of you to choose mediation as their first method of resolving a dispute. Thank you, Vikram, for inviting me again.
Thank you for being part of all my shows and events. Only you missed out on these, but okay, that much is allowed. So what I need to do, it's a 30-second thing, but I don't like to waste your time, definitely. But I just want to put out there, because what happens is that there is a lot of information. YouTube channel has more than 400 videos. So how do you find the information is the important part. So basically mediatorvikram.com. Of course, this is the symposium, the participants in this symposium. So that is a part all there. Connection, social media. I'm the most, like I say, most accessible person. WhatsApp, email, anything. Please, I do physically. I'm somewhere in this world, so I just put it out there. It's all going to be online, but just to tell people that yes, physically I do exist somewhere. I'm just not a bot or something on the screen. So support World Mediation Circle, which we need to talk about. Guna, we have to develop that. Under shows and events, basically you have the schedule. Click the schedule of this symposium, the last symposium, the World Mediators Conference. All that is there. All the YouTube links to the recordings are there. So just click this and you'll find that. YouTube playlists are there. So you can find that there. And of course, some conferences that are coming up next year, we have to make a large World Mediators Conference and the symposium on mediation, culture and tradition. Let's make a big one there. These are the various shows. So playlist, this will connect you to the YouTube playlist of each of those shows. So there are lots of them. Of course, Guna has been part of In Conversation with Beautiful Mind. Evolution of a Mediator, you can't be part of. That 70 plus. Guna is not there. Lectures about mediation, you've been there. Talking books, you still haven't been there. Mediated experiences was the other one. So basically lots of shows, lots of activity. And then what happened 2021? That was that 97 speakers, 45 countries, which of course you were part of. 27 chats, which you've been part of in 20 days. Also, there are lots happened last year. So lots also there. Everything else you can find. Ken Cloke, definitely one section of what he's been in. So all the YouTube links and everything are there. So please, now this is how much I can take. I can't take more of your time. So please go now. Colonization, decolonization, and mediation. I come in if and when you want me to come in. So please.
Can I share my screen? Vikram?
Yes, absolutely. Because Guna's the academic part of Guna. We haven't. So you haven't spoken about the fact that you are a lecturer at the.
But I like to show pictures and all that. So I thought it's
well, that's the fact that you're.
Yeah. So this is Malaysia.
You haven't shared the screen yet. You must have opened it on your screen, but you haven't pressed the share screen. Yeah. On Zoom, you'll have to just press the share screen.
Let me just end my show. I haven't shared screen. Hang on. Okay, share screen. Yep.
Now,
Okay.
yes, now
Yes.
it's opening up.
Sorry.
Yes.
From current slide. Okay.
Yep.
Okay.
Perfect. Perfect. We're up there.
Yeah, I'll just remove that. Okay. This is Malaysia. Yeah, and Malaysia is made out of 13 states, and nine states are ruled by monarchies, like the British call them monarchies or the sultans, and they retain this after colonizing Malaysia. And we also have 3 federal territories, and we have this Sabah and Sarawak. This was actually known as the island of Borneo before, these two, but this is also now, these two are also part of, these 2 states are also part of Malaysia. Now, of course, Malaysia being, I would like to just touch about the different ethnic groups in Malaysia and what happened pre-colonization, Vikram, if you don't mind, because that is where mediation actually originated from. And then I will take you all through to the colonization era and the decolonization era and what is currently happening in Malaysia. So Malaysia is basically divided into these 4 categories of ethnic groups. Of course, the original people are the indigenous people, the Orang Asli. Then you have the Malays, Chinese, and the Indians, as per this photograph here, this picture here. As you can see, the different ethnic groups in Malaysia. And then you have the pre-colonization era. And these are the natives. These are the indigenous people, as you can see from this picture. And during prior to colonization by Western powers, there actually did exist a form of rudimentary tribal legal system. I think Cecil spoke about Bukharas. This actually existed in the peninsula of Malaysia, and there were various aboriginal tribes, and they had been in occupation of the peninsula long before the colonizers came or arrived in Malaysia. So their laws were primitive and unwritten. It was not documented, but they had very good organizational abilities. And this actually served as a model for which was later used by the Malays in their villages and in their kampongs. So, for example, the head of the village, or Pengulu, was an organizational social structure which was actually derived from one of the tribes, aboriginal tribes in Malaysia, called the Negrito tribe. So the Pengulu of this village or kampong, he usually had full civil and criminal powers over his people. So this was actually brought down subsequently which was actually practiced by the different races in Malaysia. So this third-party facilitators, as I say here, are actually people who actually head the villages, or what we call ketua kampung. Or some of them could be religious leaders. So they look at religious leaders in the temples. In Chinese community, this would be Chinese community clan leaders. And for the Muslims, it would be someone like the imam in the mosque. So all these community leaders had credible standing in their own circles. So people respected them and trusted them and allowed these third-party facilitators to actually resolve their disputes. So this was pre-colonization. So this is how typically a village elder or ketua kampung looks like. Okay. So as I said earlier, the imams or the pengulus, who are the community leaders. So all these traditions and customs and beliefs from the indigenous people was practiced as a way of life, is a way of their life, and which was actually brought forward even during the British era. And I'll talk about that later. So this concept of mediation, I mean, if you can call this mediation, which I think you should, because of course it's not in a structured form, but these mediators or third-party facilitators were actually resolving disputes for the people in their community. So mediation, in my view, is not an ancient concept at all in Malaysia. And culturally, it has been practiced in the multi-ethnic community of Malaysia. So moving on to the Malays, they actually refer to the sultans as well, the monarchs. They ruled these different states, and most of the disputes which they were dealing with, which they were solving by way of mediation, if I may put it that way, involved land matters, religious disputes, customs, and disputes within the community. So these are all based on, the resolution is based on customs and interpretation of Islamic laws by the third-party facilitator. So this is prior to colonization, and the Malays also relied on Sulo. And Sulo means the end of a dispute. So to cut off a dispute, literally to try and resolve the dispute. So these kind of disputes were dealt with by religious leaders and the village headman. So Sulo basically actually means then what they're actually doing is trying to reconcile parties, or actually mediate the disputes for the parties. So basically the practice of Sulo is derived from the Quran. And this was used to resolve family disputes during the era of the Prophet and the caliphates of Islam. So in Malaysia, this started in the state of Malacca, and it was implemented in the 14th century. So the arrival of Islam in Malaya began when Malacca became a Muslim kingdom under the reign of a sultan known as Sultan Iskandar Shah. So they believed that Islam was actually brought to Malacca by the Indian traders and became the center for spread of Malay culture and Islam in the religion. And during the reign of the Sultan in the Malacca Sultanate, they came up with the Malacca Law Digest and the Maritime Laws of Malacca. So these were all compiled and used as a reference, as a point of reference when disputes were resolved by way of Sulo. So this was actually, if I can just read a part of the digest, which says that in a property claim, an amicable settlement is lawful after the claim has been acknowledged by the defendant. An amicable settlement is not lawful when one party denies the claim, and in a case of a person who is not certain of his action. So they actually talk about resolving disputes amicably way back in 1424 in Malaysia. So this law digest, which existed, was later adapted and adopted in all the different states in Malaya, even after colonization by the British. And so this typically how Sulo is conducted, it's conducted by a third party who, as I said, is a religious leader or someone who's respected in the community. And this person is appointed by the monarch, the Sultan of that particular state. And this could be the headman, could be any one of them. And they are expected to look after the welfare of the community, the villages. So he may be appointed based on his religious background, or maybe shows of pious observance of religious duty, could be any one of these. Because as far as the villages are concerned, the imam is the symbolic of the Islamic status of that particular village, and he's regarded as an elder. So he's someone who is respected, endorsed by the monarch, and that is why he was able to mediate disputes and enforce sanctions against offenders. I mean, this also included offenses like for adultery, for fining thieves, for killing murderers. So it even extended to criminal matters. Now, next, so this was as far as the Malays were concerned. As far as the Chinese were concerned, which is the second largest ethnic group in Malaysia, and they arrived in Malaysia between the 15th and mid-20th centuries. And they originated from different parts of China. And the first Chinese to settle were in the Straits settlement, and they intermarried with the Malay community, and they actually created or gave rise to a new culture or different ethnic group called the Baba Nyonya ethnic group. And this was because they intermarried, and this is quite interesting. They embraced Malay culture, but they retained their Chinese traditions. So they practiced, their religion was either Buddhism or Taoism. So these Chinese immigrants were basically Buddhists actually. And the Taoists, they adopted Confucianism philosophies and culture. So when you talk about the Chinese immigrants, they were governed by the Capitan system as the government of the day, and they had very little interest in any activities involving the immigrants. So similar to the Pengulus in the Malay community, these Capitans or headmen looked after the welfare of the Chinese community. And they also come from different, they could be the elders, they could be neighbors, they could be clan leaders. That is how they appoint the Capitans in the villages. And because many of them are, I mean, because they of course came from China, they also referred to a process called Tiao Jie, which is the process where a third party attempts to bring disputing parties to voluntarily resolve their disputes. So the traditional use of mediation was actually brought from China, and some of the forms and techniques which they use, which was used by the Capitans, originated from China, because they brought these norms and techniques into Malaysia. And they basically resolved family disputes, marriage, and land disputes normally. So the mediators who facilitated negotiations were all these people, the elders, the neighbors, and the clan leaders. So they also practice Confucian principles of relationship, harmony, and cooperation. So the emphasis of harmony and maintaining relationship and cooperation, which are all mediation principles, as we know. Relationship is one of the main things we look out for to mend broken relationships between parties in a facilitative mediation process. And communication, cooperation between the parties. So all these concepts which we are now exposed to as principles of mediation actually existed even way before this. And the Chinese actually practice it when they adopted Confucian philosophy and Taoist philosophy. So all these, they promote individual sacrifices for the sake of maintaining peace and harmony in the community. So the Chinese actually were inspired by many people. Another inspiration for them was Lao Tzu, whose fundamental notions involve the relationship of yin to yang. So these two opposing forces complement one another simultaneously. So according to Lao Tzu, the key to life was to find the Tao, the way between the two forces, and find middle ground and compromise. I think this is what we call transformative mediation now. I mean, if I may look at it that way. I mean, because in transformative mediation, I think what Bush and Folger speak about when they talk about transformative mediation is that the important thing or the primary thing about resolving disputes by way of transformative mediation is putting a lot of emphasis on mending relationships. Relationships are the primary concern of the mediators. So I think all this does originate from the culture. So when you talk about transformative mediation, I mean, if we do more research, I mean, I haven't, I have to tell the truth, but it sounds as though it originates from these principles. So the moral values and teachings by Confucius and Lao Tzu were adopted by the Chinese immigrants who came into Malaya at that time, as it was known, to resolve conflict in the community, in the Chinese community. So they actually practiced this, and it was admirable, I must say, to have been able to resolve disputes this way. And I think it's also because the basic unit of community in China was not an individual. They actually look at people belonging to groups. So groups belong to a certain unit. So they respect the head of the family. So elders in any family or elders in a clan were actually very highly respected people. And that is why they could be the peacemakers in their own communities. They were able to resolve family disputes, land disputes, all sorts of disputes for their community, because their community looked up to them collectively. So that is the Chinese. And as for the Indians, they similarly, they also looked up to their elders, the temple priests, and the panchayat. And it is actually, and mediation actually is an age-old process of dispute resolution practiced since the Vedic period in India. So they also looked at resolving conflict within the community peacefully. So in traditional village structures, fights between neighbors or disagreements among family members were often settled with the help of a mediator or an intermediary. So it's customary again to turn to one's elders. I think Cecil spoke about turning to her auntie. It's similar here. So this was also practiced in Malaysia by the Indians who had emigrated to Malaysia. So this is not something which is new and which existed many, many years ago. So traditionally, to wrap this up, for this pre-colonization period, this was how disputes were traditionally resolved in many parts of Malaysia, and I'm sure in many parts of Asia before colonization. So now moving on to colonization.
But Gurang, is the Orang Asli different? I mean, you said the
Yes,
Orang Asli.
Orang Aslis are the natives. They were the original people here. They were the indigenous tribes.
Do we have something on them?
No, but as I said earlier, there's not much on them which I could find, but their laws, I started with them and said that their laws were primitive and unwritten, but they also relied on the village head, the Pengulu, which was then carried forward to the Malays.
Okay.
And the first colonizers of Malaysia or Malaya at that time was, of course, the Portuguese. And they came in 1511, and this was all basically because of trade. And this is a picture of Alfonso de Albuquerque, who actually seized Malacca, one of the states, and used it as a base for its activities in Southeast Asia. And in 1641, the Dutch East India Company and local allies invaded Malacca. And so they pushed the Portuguese out. They came in, they brought their own law books, and they had their own regulations from Java, and they brought it to Malacca. And these books were used as a guide by the Court of Justice in Malacca. But when the Portuguese and Dutch colonized these states, the Dutch, and because they didn't really colonize the entire country, but only these states. So the Dutch and Portuguese, merely, as I said, because of trade purposes, because Malacca was in a very strategic place to have a port, then that's why they picked Malacca. So the Dutch and Portuguese, I want to emphasize here, they did not interfere with the local administration and matters pertaining to local customs and practices. So these, what I spoke about pre-colonization earlier, that's why I had to start off with pre-colonization, is because whatever they practiced was actually carried forward even when the Dutch and Portuguese were in Malacca. So the Portuguese invented a system where each race, except the Malay race, must be represented by a leader who is called Kapitan to represent their people. Because the Malays, the monarch or the sultans were their rulers as far as they are concerned. And of course, the head will be their pengurus. So for the other races, what they did was they were expected to pick a leader called the Kapitan to represent their people. So whenever people in the community had a dispute, they went back to the Kapitan. So this was similar. It's brought forward from pre-colonization days. And so this is a picture of colonization of the British. And the British came and conquered Malaysia, and they made Malaysia a colony in 1867. Of course, they first picked again a strategic state, which is the state of Penang, because it is an island. So for trade purposes, once again. And of course, the British, when they came, they brought their laws and introduced the first charter of justice in Penang. So they introduced English law here. And what happened after that is, of course, we all know, the British came, they brought the 3 C's, cricket, common law, and the courts. So once the British came and made Malaysia a colony, there were, of course, they of course came into Penang first, and they slowly took over Singapore. Singapore was part of Malaysia at that time. And then you have all the different Malay federated states, which were ruled by the monarchs, and it's still there as it is. Penang is now, they don't have a monarch because they never had a monarch to start off with. So it's ruled by a governor now. So they are known as governors. And the British, after they introduced their second charter of justice in 1826, they started slowly introducing English common law to Malaysia. And the acceptance of the British representatives, they had dealings with the Malay rulers, and they recognized the Malay rulers as administrators of their respective states. So what they did was, remember I spoke about the penghulu earlier in the Malay community. So what the British did was they retained the post of the penghulu, but the penghulu was absorbed into their district administration because they felt as colonizers, they needed a local agent to convey their messages to the people. So, because the community, of course, the Malay community, and of course the Chinese and the Indians who were there, they could not, the British could not gain their trust. So they had to rely on these Pengulus because they realized that the community in all these villages, they gave a lot of respect to the Pengulus. So that is why they absorbed the Pengulus. And although they absorbed them, it was an administrative role. So they actually lost, the Pengulus and the religious leaders lost their status and role after colonization because they were no longer able to be peacemakers, to sit and resolve disputes for the people in their villages. All this was lost because the British had come in to introduce English common law in Malaysia. So their role, as I said, was transformed into an administrative one. And they were also answerable to a district officer who was a British citizen. So they no longer enjoyed the formal judicial authority which they had to mediate disputes. So, but in certain types of disputes, the role of the Pengulu being the head was still retained. This was, for example, it was not retained. For example, their right to collect taxes and revenues from the people were abolished by the British as well. So as for the Indians, I mean, most of the Indian migrants who came into Malaysia were laborers. So what the British did was they only offered them lower positions in the administration, and they worked as contract laborers known as Kanganis. So they were selected to recruit. What they did was they had to go and recruit workers for villages, and they were respected. So this Kangani was like the head of the Indian migrants. As for the Malay leaders, the original posts given by the sultans or the monarchs were maintained, but once again, their powers were whittled, and it was restricted only towards local or native people. So the British colonial administration, they realized that they couldn't really get rid of the Malay customs and the Malay adat, as they call it, the customs, okay? And this was especially in relation to division of property, because the Muslims, they have their own ways of resolving or distribution of land and property. So what they did was, although the British introduced British common law, English law in Malaysia, when it came to matters of divorce, matrimony, or property jointly acquired by husband and wife in the Malay community, the British actually recognized these customs, and it translated into case laws in Malaysia. So they sort of recognized these customs only in respect of issues pertaining to land. And in respect of the other two states which were part of Borneo, likewise, they transformed native customary law from being an incidence of an inherited oral tradition to a set of clearly defined written rules, which was actually operating within the court system or the judicial framework. So they formalized native customary law, the British did this, by ensuring the survival of some of the codes written by the natives. And this actually still exists. And these are some good which the British did, I guess, to codify some of the native or the indigenous people law or customs. So in addition to this, of course, English law was liberally applied, and in matters of personal law, judges made decisions on local customs. But when it came to commercial matters, trade and commerce, they applied English commercial law. So somehow the British were acceptable to applying customary laws for family disputes, but it stopped there. So then this originated into case laws, and there were two principal sources of law for Malaysia. One is legislation, which was enacted by the British, and case law based on customs of the indigenous people. So once the British came, of course, English law was commonly entrenched and became the law of the land, or what we call in Latin lex loci of Malaysia. So as I said, they came, they brought the 3 C's, and till today, of course, we are still using English common law. I think we all are. They still don their, but thank God we did away with the wigs. But our lawyers still wear robes like their counterparts in England and in India, I'm sure. And the traditional methods of trying to resolve disputes harmoniously to safeguard relationships, to promote peace and harmony, diminished with the introduction of English common law. And people slowly became more litigious, and this carried on and is still carrying on now. So let's look at so that's how it was during the colonization of the British era. And the decolonization of the British in Malaysia happened between 1945 and 1963. So basically, the opposition was revolving around 2 issues: loose citizenship requirements and reduction in the Malay rulers' powers. As I said, the Malay rulers felt very threatened, of course, because the Indians and Chinese did not have much to say till today. If I may add that, I don't want to go into politics now, but that was the case then. And as you can see, this was the revolt by the Malays. The Malayan Union is not wanted. Okay, so Malaysia was then so due to the pressure exerted, the Malayan Union, they say here in this picture here, as you can see, Malayan Union not wanted. And this was when they sat down together, and the British finally, due to the pressure exerted by the sultans, the union was replaced with the Federation of Malaya on 31st January 1948. And finally, we gained independence on the 31st of August 1957. And this is our first Prime Minister, Tunku Abdul Rahman, who this is the Proclamation of Independence. This is a very famous picture photograph in Malaysia, where proclamation of independence in 1957 on the 31st of August. So after decolonization, I mean, of course, we all continued practicing English common law. And very sadly, it was only like in year 2002 that the Malays, I spoke about the Suluh practice even way before pre-colonization days. Finally, it was set up, the Sharia courts in Malaysia started practicing court-annexed mediation in 2002 and codified enactment. And so Suluh is now codified and part of the Sharia court proceedings. and most matters, of course, this only affects the Muslims, and it's only in respect of family disputes and property disputes, which the civil courts do not have jurisdiction over in respect of the Muslims. So this continued, and as for the rest of what happened and for the growth of mediation in Malaysia, let me just share with you what happened. And very sadly, I mean, mediation only started in the 1990s in Malaysia, and it is still not taken off in a very big way till now. But when it first started off, of course, Singapore introduced mediation into Malaysia when they conducted the first mediation workshop in Malaysia, and I was one of the pioneer mediators, and we were trained by the Singaporeans first and then by the Australians, and of course this is what the structured form of mediation which we're talking about. So earlier on I referred to mediation during the pre-colonization days, and even which some was practiced during the when Malaya was colonized. This was an informal way of doing mediation by the Pengulus, by the village leaders, etc. But the type of mediation which I'm talking about now is the more structured form which exists today in Malaysia. So in Malaysia, we have, of course, the Malaysian Mediation Center. They were actually, they were the ones who, which is actually an auspices of the Bar Council of Malaysia. So I am one of the mediators of the Malaysian Mediation Center. And they set up the center first. And we have about 300 over mediators now. But of course, mediation hasn't, as I said, hasn't really taken off in a big way. Even the Mediation Center does not really conduct that many disputes. It's negligible compared to what is being done in Singapore. So it's very sad that it has not really taken off in a big way. The there are also other organizations conducting mediation in Malaysia, like the CIDB, which is the Construction Industry Development Board. This is basically for construction disputes. But again, I think the statistics are very poor. And then we have the Asian International Arbitration Center. Of course, they also promote arbitration, mediation, and conciliation. So again, mediation always takes a backseat. So we need to do something about this, Vikram. So, of course, arbitration is in the forefront. And SIDRAC is our financial dispute resolution center for securities disputes. So for financial disputes, we have this. Oh, I've missed out one more, which is by our bank, Bank Negara, which is our the national bank, and they promote what you call mediation, but they now refer to the mediators as ombudsman. So this was created to resolve financial disputes, but their jurisdiction is very limited. I believe it's only up to 300,000 ringgit, so it's not much. So other than that, actually, mediation has only taken off in a big way in the courts, actually. And this was when court-annexed mediation was introduced in Malaysia in 2010, and by way of a practice direction. Of course, this is what we call sometimes or refer to as judicial-led mediation. And in this practice direction, it specifically stated that ADR is encouraged for these type of disputes. So personal injury, road accident cases, defamation, matrimonial, contractual, commercial, and intellectual property disputes. So they actually have set up mediation centers in all the 13 states in Malaysia, we have mediation centers. So mediation is conducted either by the sitting judges, or the sitting judges then assign their mediation cases to the mediation centers in each state. So which is housed in the same court premises. So it's easy for people to access these mediation centers. And the mediation centers actually are very busy. They conduct at least 4 to 5 mediations in a day, and they have like about 3 to 4 mediators in each state. But some of the smaller states, they only have fewer mediators. So this has taken off in a big way, and compared to private mediation in Malaysia, because I suppose the thinking is court mediation is free, so why should we pay private mediators? So that has become another big problem for private mediators like me, because if our peers, our colleagues, lawyers, do not refer disputes to us for resolution, instead they tell their clients, let's just go to court and try this, or some even use it as a fishing expedition. So we lose out as private mediators, and whereas the court's statistics have really improved tremendously, because they do resolve many disputes by way of mediation. And I also want to talk about community mediation in Malaysia. And community mediation is not something which actually started way back in 1975, because they had what we call this Rukun Tetangga, which was set up to preserve religious, racial, and community harmony in villages and in certain districts. So they sort of replicated the traditional mechanisms for resolving community disputes. So this is a very laudable effort by the government of Malaysia. And this was introduced under the auspices of the Department of National Unity and Integration. So the aim of this program was to foster unity and integration among the people, and at the same time provide an opportunity for residents to resolve disputes at the community level without going to court or government agencies. So as I said, it's a laudable project. And the pilot project took off actually in 1975, and it was known as the Peaceful Neighbor Regulation. So this was way back from 1975. So in it was finally formalized and legislated, and the Rukun Tetangga Act actually came into force in June 2012. So if I may just read one of the provisions, it says here that the aim or the functions and duties of the Rukun Tetangga Committee is to provide community mediation for the purposes of conciliation or otherwise settle any dispute or difference amongst the members of community. So this provision actually fortifies the government's efforts in promoting community mediation for resolution of disputes outside the purview of the courts. So community mediators under this program, they actually they are required to undergo a skills course of community mediation, and they're actually given like 20 steps to follow as a guide when they offer their services as community mediators. So it's quite interesting. And then lastly, we have the Justices of Peace. Actually, the Justices of Peace is actually a heritage of the British rule in Malaysia. And these district officers and assistant district officers are appointed as Justices of Peace to alleviate the inadequate pool of magistrates in the state, especially this was in the state of Penang. And ironically, that is the first state which was invaded by the British. So at present, the JPs or the Justices of Peace are appointed by the state authorities and are conferred powers not exceeding the powers of a second-class magistrate in Malaysia. So here in Penang, what they do, the Justices of Peace, they have promoted neighborhood mediation, and they have also set up the Council of the Justices of the Peace Penang to advance the use of mediation to cater for the community, especially the business community, to try and resolve conflicts within the business community. And as I said, they have all they do this on a pro bono basis, and therefore making it accessible to the public to have their disputes resolved. So this is what's happened in Malaysia. And currently what is happening in Malaysia is we are trying to ratify the Singapore Convention, and hopefully we ratify it and amend our current Mediation Act, which I think one of the main reasons why mediation has not taken off in a big way in Malaysia is because in Malaysia, what has happened is, as I said, people don't value mediators. They feel that what is mediation? Oh, it's a waste of time. And some of them just use it as a fishing expedition. So it's very frustrating for people like us trying to promote mediation in the country. And one question which they always ask us mediators is, oh, is mediation a binding agreement? So he said, of course it's binding like an agreement. They said, no, but can we go to court and enforce it? Well, the answer is no, because you have to start it like a contract, because there's no automatic recognition like enforcement of a consent order or a consent judgment in court. That is what is lacking in our Mediation Act in Malaysia. We have a Mediation Act, and sadly we do not have any enforcement rules. So that's another reason why court annexed mediation has taken off in a bigger way than private mediation, simply because in court annexed mediation, after the mediation center mediates the dispute, and it is then sent back to the assigning judge or the assigned judge, who then records consent judgment in the court. So it has that oomph or that force of law, which private mediation agreements do not have. So that has become a big hindrance in Malaysia. So if we were to ratify the Singapore Convention, because this would help push mediation in a very big way in Malaysia, because people in the business community will be able to enforce their international mediated commercial disputes, agreements. And of course, if we were to ratify it, we would have to amend our local Mediation Act to give it that same force of law. And hopefully with that, mediation will take off in a bigger way in Malaysia. Thank you, Vikram.
Thank you, Guna. Of course, there will be questions, definitely. But
Sure.
important thing is that you spoke about transformative mediation. Of course, we should say hi to Armando. Armando's session is next. He's from Ecuador.
Hi.
And of course, we're waiting for our official translator. Sebastian has been very nice to offer, so he'll also come in. So Armando, you can all put on your video and say hi to us. So you spoke about, hi Armando.
Hi Armando.
Hi. Hi.
That's Guna. Guna is in Malaysia.
Hi.
Nice to meet you.
Nice to meet you too. We are poles apart. Really.
Not so far away. It's okay. We've all connected now. It's a connected world.
Thanks to you.
Yes. But in terms of transformative mediation, you spoke about that. Baruch Bush was in that conference, World Mediators Conference. You
I
should
know,
have
I
been
missed
there.
that.
You should have asked him all these questions there.
I
You should
should
have,
have.
yeah. But I think the important thing that's coming out is that, like you said, sacrificing individual interest in, when it comes to the community. So I
Yep.
think that is where the starting point is. Either if communities already exist, obviously it'll be easier. But if communities themselves are broken down, getting them together, and which is where I have been trying to connect colonization, because the colonizer, in your case, you're saying that I don't know how much they got entrenched into that, but largely the concept of the colonizer was don't let communities get together. Put a dividing aspect to
Yes.
it. Could be religion, could be anything. Yeah.
They used that as a tool.
Exactly.
To divide and rule, actually. I think
Absolutely.
you spoke about divide and rule earlier. I suppose they practice the same thing everywhere, even in India, I'm sure.
Exactly.
Yeah. So that is what they did in Malaysia as well. So
yeah. So that's what I'm saying. I think we need to first I think let's not unlearning really. It's actually changing the structure. I think that will be one role of mediators. So people with the mediator mindset is what you heard me enough of that. It's not about them, maybe that whole professional concept that's being developed. I'm not interested in that. The people in the community with that mindset, I think first step seems to be that this world mediation circle and mediation circles that I'm developing, that would be one role of those people to bring the community together. I think that seems to be the aspect. But on the Orang Asli, you're saying primitive methods. I am saying that those might be the purer aspects. If Cecil is quoting that aspect that you had, definitely there's something good about it. Of course, she's picked it up from William Urey's book. It seems there was a footnote on that. But still, I mean, it's something which I think we need to look at and not look at it as primitive because of the fact, I mean, in the sense, primitive not being inferior. That's again what the colonizer did. Colonizer told you that your methods are inferior. I am bringing you something superior. I think we need to get over that also.
Yeah, it's true. And till today we're still caught up with English common law.
Exactly. So, but only thing, what happened to the cricket? Common law, you picked up
cricket. Yeah, I said they got the three things: cricket, common law, and the court.
Cricket, nothing much happened in Malaysia, is it? I don't know. I don't know.
No, nothing. Not like India. Definitely not like India and Pakistan.
But when you talk about, I tell you, a lot of people quote Singapore and say a lot of mediation is happening there. But I look at the figures of the Singapore Mediation Center. In 25 years, 5,200 matters. What is that? That's nothing. I mean, I give an example of India and the millions of matters which are lying in court and otherwise. You can't even look at those figures.
Singapore is such a small nation.
No, but they talk of themselves as being the hub of mediation. So they're looking at international also. It's not about the domestic. They're looking at international. But I'm saying the numbers in terms of institutions are not there. Those are the ones you hear about. Okay, this is where mediation is happening. I'm saying that is, yeah.
But sorry to interrupt, but they have community disputes, they have community mediation, they have peer school mediation. I don't know whether that comes within those statistics which you're talking about.
No, it won't. That won't. That because this is the Singapore Mediation Center. But
exactly.
Because of what I'll tell you what I'm trying to bring together is that on one end, again, this is a colonization mindset of qualifications and training, which brings together these institutions, but numbers are not in those institutions, and these people who think they'll practice as mediators go through that route. Obviously the numbers are not there, they will get disillusioned. They can. So I think we need to bring it back into, of course I'm starting at the grassroots level, and not just grassroots, I'm saying whatever communities, be it organizations, be it business communities, like you said, I mean, business communities are important to bring it there. So let's do it without these qualifications and structures which are available. Let's bring it as informal. That whole informality of it, I think that is getting lost in what is being put across as mediation. I don't even,
It has gotten lost. I'm sorry. It has gotten lost. I mean, it is now moved on from that primitive method, as I said earlier when I first started off, to something which is structured.
Yeah. So I think we might have to look at that. We have to look at it as whether we want it to go like that. But you spoke about the ombudsman. the concept. What I'm doing is on 13th of October, there is a International Ombuds Association, which has has put out October 13th as Ombuds Day. In the conference, World Mediators Conference, I had a discussion on ombuds versus mediators and mediators versus ombuds. I mean, basically, ombuds versus mediators. So this one, I'm having a discussion on ombuds as mediators and mediators as ombuds, because I want to look at that concept. But the ombudsman that which governments have created are not really doing it as mediation. They become arbitrators, and that's how that process has gone wrong. I mean, in a sense, as a word, which is what I was telling these ombuds, which I had that discussion with, that word might create a problem because countries have introduced the ombudsman as a different total structure. Yeah, so we need to maybe move out of that. The Singapore Convention, I'm saying that, look, I still feel, like you said, your act doesn't have teeth in relation to that settlement agreement being as good as a court decree, which India has, which people in India say we don't have a mediation law, and I say we have the best law. Everything is there. So it is a little funny, okay? Because no one goes, so simple, Guna. All they have to do is look at how we got that law. We got it because Uncitral had made a model law. We took it at the right time, 1996. Can you imagine? We were so far ahead in our time in looking at it. And that is the word, the conciliation was the word they were using. No one even goes that much back into this whole legislation and starts saying, oh, we don't have a law on mediation. Uncitral, because it understands these people who are confusing things, in this new model law, specifically clarifies this, that we were using this word, now we're using the word mediation. There is no difference in the two. So we have a law on mediation. And the good part is that settlement agreement is as good as a court decree. It's as good as a consent award, is as good as a court degree. So is there colonization? I'm saying in Malaysian concept, is it a colonization mindset that the people should not have the power to do things within themselves? Courts have to come into the picture somewhere. We have to break that aspect.
Yes. I think they still are stuck with this mentality that you must still, it's the court who can resolve these disputes.
Yeah.
They can't seem to get away or move away from that mindset.
Okay.
So we need to talk about that. I think.
Yeah, because you are still hoping that when the Singapore Convention is ratified, your domestic law is going to be looked at. We don't know whether they will.
People are shying away from using mediation.
Which I'm saying that we'll have to work from the grassroots level, which
India is also coming up with their Mediation Act.
Which is the worst thing that has happened. That is the colonizers' legislation. We today have a people's legislation. This is moving towards a colonizer thing. Make it so complicated that people can't understand it. So they should go to a lawyer and in some way get the judiciary into the picture and all that. But now it's Armando's time. We have moved into Armando, where is your
Armando, sorry, very sorry, I've eaten up into your time.
Look, Armando, I don't know where your interpreter is coming. Did you have some conversation with him? Did you speak to Sebastian?
No, I don't communicate.
No, because
I don't have the number of Sebastian.
Okay, you didn't get in touch with him. Okay, because now the only thing is that whether. But Armando, you can speak English. There is no problem. I know you can. So don't worry. If you want to give your presentation in Spanish and then give it in English, totally up to you. So language should not be an issue. What do you say, Guna? Language should not be a problem.
Agreed.
Yeah.
Can always be translated later.
Exactly. So whatever, Armando, whatever you're comfortable with, I know you can speak English and you can also give the presentation in both languages, but please go ahead in Spanish. I'll send an email to Sebastian to check where he is. And if you want to yourself tell us in English later, totally your wish. Right?
Okay.
So we'll just say bye to Guna. Guna, you want to stay for the session?
No, I have to take leave. Thank you very much again for the invitation, Vikram.
Thank you, Guna. Always a pleasure having you, and please continue being a part of events. And this ombuds thing also on October 13th that we're having this discussion. I think that's a thing that I need to discuss, because organizations should have, what I'm saying, the ombuds word might be confusing, but they should have a mediator available in organizations. So let's see how that can develop. So we'll look at that.
Thank you.
Thank you. See you.
Armando.